Palestinian people use force to resist foreign oppression and complete the establishment of an independent state is inalienable right, well founded in international law.
On the fourth day of the hearing of a case questioning Israel's decades-long occupation of Palestinian territories at the International Court of Justice, China, much like the rest of the dozens of countries presenting their argument at the Hague, criticized Tel Aviv for deliberately preventing Palestinian self-determination. However, it went one step ahead when it explicitly, in no unclear terms, defended the right of Palestinians to achieve self-determination, even through an armed struggle.
In pursuit of the right to self-determination, Palestinian people use force to resist foreign oppression and complete the establishment of an independent state is inalienable right, well founded in international law. Various people freed themselves from colonial rule and foreign oppression to realize independent statehood after World War II. Their practices serve as convincing evidence for the right.
And the Chinese representative backed his arguments not with rhetoric, but by citing and quoting international conventions that protect this right.
Armed struggle, in this context, is distinguished from acts of terrorism. It is grounded in the international law. This distinction is acknowledged by several international conventions. For example, Article 3 of the OAU Convention on the Prevention and Combating the Terrorism of 1999 provides that, I quote, "The struggle waged by peoples in accordance with the principle of international law for their liberation of self-determination, including armed struggle, against colonialism, occupation, aggression, and domination by foreign forces, shall not be considered as terrorist acts."
However, Beijing stressed that genuine acts of terrorism are another matter. Israeli authorities since 1967 have illegally occupied the West Bank and East Jerusalem, part of Palestine under the United Nations Determined Division of Historic Palestine in 1948, running a system that restricts the citizenship rights of Palestinians, hampers their free movement, and strips them of ancestral lands. Between 1967 and 2005, Israel also directly occupied Gaza, and since 2007 has imposed a land, sea, and air blockade on the coastal enclave. China blasted United States' previous arguments on Israel's right to self-defense in the context of the relentless war Tel Aviv is pursuing in Gaza since October 7. It also took a veiled dig at the argument presented by the United States the day before, where it urged the court not to order unconditional and immediate withdrawal of Israel from the occupied territories without security guarantees, citing safety concerns. The Chinese representative called out Israel as a foreign nation occupying Palestine and stressed that the right to self-defense lies more with the Palestinians than with the Israelis.
It is more urgent than ever to proceed to a Palestinian state, one that also ensures the security of Israel and makes the necessary commitments to do so. In light of these considerations, the court should not find that Israel is legally obligated to immediately and unconditionally withdraw from occupied territory.
The exercise of the right to self-defense as an inherent right of states is contingent upon the occurrence of the armed attack against territorial sovereignty of a state. When can an occupying power invoke the right of self-defense? It hinges on whether the armed attack occurs in the occupied territory or within its own territory. In the occupied territory, the right of occupying power to self-defense depends on the legitimacy of the occupation per se. If occupation is unlawful, the occupying power can neither acquire territorial sovereignty nor resort to self-defense against armed attack that occurred in the occupied territory.
Beijing also countered Israel and its staunch ally Washington's suggestion to the ICJ that it should stay out of a bilateral issue between Israel and Palestine.
Others have asked you to broadly construe the questions and the law. They have asked you to try to resolve the whole of the dispute between the parties through an advisory opinion addressed to questions focusing on the acts of only one party. The United States disagrees with that this approach would be consistent with the Court's role within the United Nations or the established UN framework for achieving peace through negotiations.
The Court has jurisdiction over this case, and there is no compelling reason for the Court to decline to exercise its jurisdiction. First, the subject of present request falls within competence of the General Assembly and has always been on its agenda. Therefore, the Court, by rendering advisory opinion in this case, would not circumvent the principle of consent in the settlement of bilateral dispute. The question of Palestine with origin in this mandate system on the League of Nations go beyond the scope of bilateral affairs between Palestine and Israel. It directly relates to the responsibility of the UN on international peace and security. The UN has permanent responsibility toward the question of Palestine. Second, the issuance of advisory opinion by the Court would not contradict the established legal framework or disrupt negotiations to settle the question of Palestine in accordance with international law.
Israel has rejected the World Court's jurisdiction over its rule of the West Bank, arguing that advisory opinions should not be issued when the essence of the matter is a political and not a legal dispute and is therefore beyond its jurisdiction. The ICJ is hearing from about 52 countries on their opinion about the occupation and is part of a push by Palestinians to get international legal institutions to examine Israeli policy. The judges are expected to take roughly 6 months to issue an opinion. A ruling from the ICJ in this case will only be an advisory opinion and non-binding and have very little impact or legal ramifications for Israel. Nevertheless, the status and prestige of the ICJ means that what transpires in The Hague will have some symbolic importance to Israel's international and diplomatic standing.